Let's go ahead and get started. This is the meeting of the full committee of House Insurance, and we have on the agenda three bills today: House Bill 1371, the Pharmacy Audit Bill of Rights; House Bill 1484, Personal Insurance Insurable Interest; and House Bill 1456, which is Accident and Sickness Policies, Age of Dependent Provision. And we'll take House Bill 1371, Pharmacy Audit Bill of Rights. Representative Graves. Oh, here, you can sit down. Yeah, I forget what room we're in.
Yeah, I never know where you want me to go.
At your age, you probably need to take advantage every time you get a chance.
And that's, yes, sir. You are so correct. There's a lot of things you don't pass up when you get to be this age.
A lot in your business anyway.
Yeah. Thank you, Mr. Chairman and members of the committee. I bring you House Bill 1371. You should have in front of you a substitute, which is LC 33-1456S. This bill basically, as many of you are aware, when you go to a pharmacy, you have a prescription drug card, which pays for a portion of your prescription benefits, and you usually have a copay. Those are contracts between insurance agencies and PBMs, which are pharmacy benefit managers, and part of those contracts allow for them to come in and audit those prescriptions to be sure that everything is valid and there's no fraud and neglect and that sort of thing. They're paying the right amounts for the people that they're handling those processes for. Over the last few years, there has been a lot of issues come to light. These are not negotiated contracts. It's a take it or leave it sort of thing. Here it is. We're going to do it. And so due to some issues that the pharmacy community has expressed concern with, you now have House Bill 1371, the Pharmacy Audit Bill of Rights. It's a very basic bill. It just asks for some basic rights for the pharmacists that are being audited by these companies. I'll run through it just briefly for you, and then I'll let you know the changes that we had from the subcommittee yesterday. And Mr. Chairman, I do want to thank you and the members of the subcommittee for giving us the opportunity to have such a lengthy hearing and the ability to work with those concerned and amend the bill. So I think we have a pretty good bill today for you. In Section 1, line 19, number 1, this is what the Audit Bill of Rights contains, that the auditing company will give us at least 1 week's notice before they come in to audit us, so we can get all of our information together. Section 2 deals with yesterday the bill said that it had to be conducted by a pharmacist licensed in this state. There are some issues that does not require pharmacists to do that, and so you'll notice that we have added the language, any audit which involves clinical or professional judgment shall be conducted by a pharmacist. There's pharmacy technicians or other people can just make sure that the right thing and quantities were dispensed according to the prescription. Number 3, any clerical or record-keeping error shall not constitute a willful violation and will not subject criminal penalties or without proof of intent for fraud. Sometimes, just like I say, these clerical errors, pharmacists have been held liable for that as a willful violation, and everything has been recovered. Number 4, on page 2, that a physician's record may be used for the purpose of validating a pharmacy record. If for some reason one of the pharmacists in my facility does not document appropriately, but then I can go back to the physician and say, hey, I called your office, I got verification for this, and they can produce documentation which says, yes, the pharmacy did call, we verified a refill. I can show that as evidence that, yes, we did the things that were required of us, and that will validate my pharmacy record. Number 5 deals with a situation that is really been a bone of contention for us. Finding of an overpayment or underpayment must be based on the actual overpayment or underpayment and not be a projection. What's happened in the past is they'll come in, look at 3 or 4 prescriptions and say, hey, we overpaid you a certain percentage. Then they say, oh, let's look, we've got about 200 prescriptions of that nature that we paid for, so we're going to project you had that same percentage error all the way across that book of business, and we're going to recoup this much money from you. All we're saying is if you overpaid me, take the money back. I mean, they have the records of each and every prescription that we did. Let's look at them. And if, what may have happened is the fact that one or two were filled incorrectly with the wrong quantity or wrong something that violated the particular audit procedure. And therefore, I caught it at some time later, changed it in my records, and from that point forward, we never had that mistake again. Well, let's pull it and look at it. If you overpaid me, take the money back. But if I corrected that error, let's don't use a projection, and therefore you're taking money back that I actually did the appropriate thing on. So let's verify that amount, is what that says. Section 6 deals with the same standards and parameters shall be used as all other pharmacies. Let's have a basic standard and parameter that you're going to operate under, so we'll have some standardization throughout the industry on that. Number 7, pharmacies shall be allowed at least 30 days following the receipt of a preliminary audit report, which to produce documentation to address any discrepancy found. Yesterday in subcommittee that said 10 days. So what we've done is a lot of them currently today, there are 30 days out there, so we just changed that and took their language. They said, let's give us 30 days to, as I talked earlier in number 4 about using that physician record, I can get that documentation together, turn it in, and say, here, this backs up and shows why I did what I did. Section 8, that the audit period may not exceed 2 years from the date that the claim was submitted or adjudicated by the managed care company, insurance company, third-party payer, or Department of Community Health under Article 7, Chapter 4. Yesterday in subcommittee, we had that this was a 1 year. Was it all they could go back and audit? After discussions with the parties concerned, we felt 2 years was what was a little more reasonable, because sometimes it takes a little longer to get information together to determine that they're going to have these audits. So we changed it from 1 year to 2 years, and then on lines 14, 15, and 16, that language was added, which is just picking up the present language on page 1 that deals with and it spells out managed care company, insurance company, third-party payer, or Department of Community Health under such article. Line 17, number 9, the audit may not be initiated or scheduled during the first 5 days of the month. That is the busiest time for pharmacies, and we're just asking to give us a little break there. Yesterday, we just said it was going to be scheduled during the first 5 months, but we took their language and said, hey, may not be initiated or scheduled. So the first 5 days, it will be an excluded time period for audits. Number 10, that any auditing company will not be remunerated for services based on the amount of funds identified to be recouped. I mean, if I do something wrong, take the money back. But if you find $10,000 error, and then that company's going to get a 10% finder's fee, so to speak, they get an extra $1,000. You just wouldn't believe the nitpicky things that are, and I have documentation where just things such as, if I get a pack of birth control pills from a physician for a patient, the doctor writes take as directed, and I put take as directed on that label, which is what the physician ordered, then the company comes back and says, no, that's a violation of your contract. We're not going to pay you that way, just because of the directions on there. Number 11, preliminary audit must be delivered to the pharmacy within 90 days after the conclusion. I think that's reasonable. After you conclude it, please just give us the preliminary report within 90 days after it's finished, and a final report to the pharmacy within 6 months after that is finished, so I can prepare for the appeal if one is necessary. Number 12, that no sections of this, the criteria set forth in this, will be applied to any claims that are submitted for payment. They will not apply until those claims after July the 1st. This won't go backwards, except for the section about the using the projection or extrapolation in calculating recoupments for audits, which is a reference to Section 5 above. C, on line 29, says that the auditing company just establish a process under which I can obtain a preliminary review and possibly an ad hoc peer review panel, so that I don't have to go get a lawyer, come in there and fight on some of these just small technical issues. At least give me an opportunity to present my grievances, be heard, and then if that doesn't satisfy it, then we can go forward with the more litigious manner of fighting this particular audit.
This is an anti-lawyer bill, is it?
Oh, no, sir. We love lawyers, especially those that are chairman of the committees we're presenting in front of. Line 36D says that the entity shall provide a copy of the final audit report to the plan sponsor. These groups do not work, for themselves. Companies employ them to handle their pharmacy benefits, and we just want to be sure that if they recoup money back from pharmacies, that the plan sponsor, the employer, gets that money, or at least has the report, understands that's been recouped on their behalf, and the money should go back to the plan sponsor that is paying this company to do that. And page 3E, the final section, this code section shall not apply to any investigative audit which involves fraud, willful or misrepresentation or abuse. We want to make it clear we don't want to set this up and have any pharmacy be able to hide behind the fact that we have an audit bill of rights if they are committing fraud, willful misrepresentation, or abuse. Now, this is a change from yesterday. After the word audit on line 1, it did say where there is reliable evidence that a claim that is the subject of the audit, and then continues on, involves fraud or willful misrepresentation or abuse. We removed that because that was vague and evasive language where they had to prove that those fraud was going on. So we did not want to tie the hands. If they truly feel like there's fraud or abuse, they can go ahead and have the investigation. They don't have to have that evidence beforehand before they go in and do the audit. So we removed that section of the language to make it clear that we don't want to in any way inhibit an investigation where they feel that audit, fraud, or abuse, where fraud, abuse, or willful misrepresentation is going on. And that's simply what it is, members of the committee. It's a very simple bill. I think it just sort of spells out some basic rights. I don't think anybody could argue with the fact that those being audited, they're taxpayer bill of rights in this country. There are all kinds of other things, and this just comes under that same vein where, we're not saying you shouldn't have them. We're not saying they shouldn't take place, and there shouldn't be a proven fact of wrongdoing, but just give us some basic parameters under which we can operate. And I'll be happy to answer any questions this time.
Questions of the members? Representative Forster.
Thank you, Mr. Chairman. Sorry for my tardiness. We had an appropriations meeting. Did you start over? I'm just kidding. Reading through.
Play the tape back.
No, I was reading through the bill. On page 1, number 1, entity conducting the audit must give the pharmacy notice at least 1 week prior to conducting the initial audit for each audit cycle. I've been involved in audits for different industries, and some of those were scheduled audits and inspections, and others were unscheduled. Are you saying all these have to be scheduled? Because almost always the scheduled audits, the notified prior notification audits, will always seem to be better than those when we just popped in and went through.
Well, what you have to understand is the volume of what these audits do. They don't come in and say, we want to see all your records for a year or whatever. They'll say, all right, they walk in here, we would like to see 3 months worth of claims data, which they already have, because the pharmacy does everything by electronic transmission. They already know what they paid for, and you have to get backup documentation for it. That's not documentation that can be made up if I know they're coming looking for it, I can't make that up. The doctor had to written the prescription, has to be refills on it, has to be a covered drug. They've already got what they just want me to produce that, so all I'm doing is pulling records together. And when you're in a pharmacy and you're working and things are going on, all they want is record production, and we have to stop, go back and pull all, because it's there or it's not. There's no, maybe. It's there or it's not. And we have to stop and go do that. And all we're saying is just give us a week so we can get all that record production together.
Thank you, sure. That makes sense. On number 2, it says any audit which involves clinical professional judgment must be conducted by a pharmacist licensed in the state.
Right.
And now, is that a pharmacist selected by the auditing company?
Yeah, that's that they do that.
Just
We,
make sure that the
yesterday,
audit is a-
yesterday we did not have that clinical professional judgment. It said that on the subcommittee we had an audit must be conducted by a pharmacist licensed in the state. But the point was made yesterday, not all audits require that, and that would be an extra cost. So just those that require clinical or professional judgment should a pharmacist be there. Otherwise,
That was a change.
yes, that was a change.
Thank you. On number 5 on page 2, finding an overpayment or underpayment must be based on actual overpayment or underpayment, not projected. Is there what's the reasoning behind that? I mean, like you said, do you want to pull out every record and have them go over every record for a year or 6 months? Or
No,
would
sir.
you rather find a trend and have a projection?
Well, no, sir. What happens is they will come in and pull a certain amount of records and say, all right, we're going to go through all these, and they look at the first 50, I don't know, and say, well, we're finding a 2% rate or whatever, so we're going to say you made a 2% error rate across the board for everything. Well, when we're talking about, pharmacy costs, understand that pharmacists are reimbursed. You have a product cost, you have a fee for filling, then that's the total amount the pharmacist gets. Subtracted out of that is the copay by the patient. And the final minus that's what the insurance company sends us the reimbursement for. What happens is, so where, I'm getting $3 or $4 per prescription is what I'm getting paid on my pharmacist fee. The rest of it goes to product cost. When you come in and project that you may have a 2% error rate across the board, that's a significant hit. I mean, we're talking audits anywhere from the $2,000 to $1.5 million recoupment. Well, if you overpaid me, take the money back. That's fine. That was an error or whatever. But let's don't use a projection, because we're talking about such small amounts of dollars across the board that we, if you overpaid me, I'll give you the money back. There's something wrong there. But let's just don't say maybe we overpaid you, because there have been situations in my own personal experience where I've loaded a drug incorrectly as far as conversions go and computer calculations, and it was wrong. Well, you catch it pretty quickly, and you go back in your system and you correct it. Well, from that point on, it's not ever going to be an error again. So let's don't say, if I fixed something, then I'm not liable for it. If you overpaid me, I'll give you the money back. That's correct. We did stick underpayment in there, but I've never had anybody come back and tell me that I didn't bill them enough and we're going to give you the money. That just really doesn't happen.
Okay. And one final question, Mr. Chairman, if I may. On the mediation portion, on page 2, down in section C, that mediators are not lawyers, I believe.
Lawyers, mediators can be lawyers. They probably all should be lawyers, but
And some of them are not. Yes, sir. I didn't see, let's see, who it would be selected by.
That's the auditing firm. The auditing firm, we're just asking for them to please establish a process that we can obtain a preliminary review without having a full-blown, let's come in there, have to go hire an attorney. If I can come in and sit down with a group and say, whoa, here's what happened. Here's the way it is. Let me have this review process. And then that's their group that they pick. We're not tying their hands. We're saying, give me a process without having to go to the full. If there's just some clerical errors or some other thing that I can prove is wrong, let's remedy it there before I have to go the full legal gamut.
And the point I'm trying to make is mediation normally is supposed to be, unbiased. The selection, you're letting the audit company select the mediators or the ad hoc committee by some third party, say the Department of Insurance Commissioner or something.
We're just asking to please establish. I'm not saying in anything in this bill that these groups aren't necessary, that they don't perform a very vital function. We're just asking, let's just have some reasonable standards that we know are going to be there when we have to go before this.
Thank you, Mr. Chairman.
all right. Representative Meadows, did you have another question? Did you have a question? No other questions? I don't have anything down for any other questions from any of the members then. Representative Chairman Dodson. I'm sorry? We have other testimony. I'm not planning on having any other testimony. We had extensive testimony yesterday. If somebody has some reason they want to call a particular witness, I'll consider that requested. have a witness appear on, but what I'm hearing is that we had an hour and a half worth of testimony on this yesterday. We have a compromised bill here, and so I'm not planning to call witnesses again to repeat the testimony from yesterday.
Okay, it's proper time for the motion.
Yes, sir. I recognize you for that purpose.
All right, Mr. Chairman, I make a motion to do pass on substitute to House Bill 1371.
I have a motion and a second for a due pass on House Bill, substitute House Bill 1371. All those in favor signify by raising your right hand. All those opposed, get it done. All those opposed. All right.
Thank you, Mr. Chair and members of the committee.
I'm going to take House Bill 1484, Representative, I'm sorry, I took it out of order. I'm going to take, Representative Weathers, you ready with your bill? I'm going to take House Bill 1456 then. Yeah, well, it's good, just to show we don't have any partiality here, and you read this one, we have to go to committee.
Mr. Chair, they're handing out a substitute on 1456, and it'll be LC 370129S. Found out yesterday afternoon it was in the wrong section, so we've made some changes.
Very good. All right, I think we can. Representative Davis, do you have a copy? Representative Dodson, did you get a copy yet?
I don't have a substitute.
Okay. Here, you want this, Steve? Let me have this one. You got one, Ron?
I'm fine.
Okay. All right. Representative Meadows, go ahead. You can proceed.
Thank you, Mr. Chairman, members of the committee. I bring House Bill 1456 by substitute, and it's to amend Title 33 of the official code. The reason for the substitute is because of where we had put it in the code. We had the wrong number, and it caused a little bit of a problem with group health insurance. There's 4 sections. First section is dealing with individual policies and what they do. Basically, right now on an individual policy, if you have a dependent child, when they reach age 19, if they are not a full-time student, they are dropped from coverage. All this does is move that 19 through age 25. If you have a dependent who is 25 up through 25, you can cover them on the insurance. They don't have to be in a full-time college student. The second section of that relates to individual policies also. And what it does, if you'll notice down at the section B, if somebody has an individual policy and they decide that because of whatever reasons, whether it be economic or whatever, that they want to reduce their coverage, and that means they'll take a higher deductible or less coverage, they can apply for a policy at renewal date for that policy and not have to go through pre-existing condition or evidence of insurability. They have been covered. If they haven't been covered long enough to get their pre-existing covered, it will run through the appropriate time. Normally it's 12 months, but some go further. All this does is let them take a lesser policy without having to go through pre-existing or evidence of insurability. Section 3, which was Section 1, and that was, we had to get them in order, if you wonder what that was, basically does the same thing as the same thing on number 3 is number 1, but it's for, they're out of order something for me, so y'all live with me for a second. It's the same thing that gives them the opportunity to, if you are terminated from an individual health plan and you have been covered under your parents, this gives you the right to buy an insurance policy without questions. You can do it as long as you pay the premium and you do it within a timely manner. Section 4 goes back, this is the part that goes to group insurance, where we move the age on the individual policies from 19 to 25. This moves the individual's age from 19 to 25 on a group policy. Any questions? Yes, ma'am. Oh, I'm sorry.
Representative Sinkfield?
Out of curiosity, what is the limit for the policy for a child that's in college?
It's
What's the age limit for that? I mean,
25.
It's 25?
Yes.
Okay, so you're making those two.
I'm just doing away with telling you you've got to be in college to be a dependent. If you are truly a dependent of your parents or your guardian, you can stay on that policy until you're age 26.
25?
It's through age 25, so at age 26 you've got to come off.
Okay, I just wanted to know whether they were on the same level as the college students, that you really are paying big bucks and keeping them in college.
Yes, ma'am.
All right. Representative Forster?
Thank you, Mr. Chairman. Thank you, Representative Mills, for bringing this. And I believe some of this came from our study committee information on insurance that we had. And I appreciate you bringing this to committee. We had a couple of hearings where we had people with disabilities that were dependents of the family, but when they turned 19, that they had lost insurance. And so I believe this goes along with fixing that situation. I appreciate you bringing this before the committee.
Like Mr. Dodson said, this is probably the most healthy group of people that we've got insured anyway, and we'd like to continue them to be being insured rather than fall on the rolls of the uninsured.
Any further questions of members?
Just one. Criteria being determined as a dependent, that just somebody who's claiming on their parents' tax returns?
Yeah, yes. If you're on your parents, if you're listed as a dependent on your W-2, that's what you're going to get. That's what qualifies you here.
Representative Dodson?
Mr. Chairman, I'd like to just keep, on Representative Mudders, just keep in mind that when you have a part-time student in college, it's kind of hard to prove how many hours, so forth and so on. So I think this really just clears it up for the insurance companies on how to handle it, because I've heard of some people that have kind of added some hours to their son or daughter's school so that it would work. I think it just clears it up to make it all the same playing field.
It does, because in normal situations you have to have something from the college saying that you are or not, and then it gets into how many subjects you've dropped during the semester and what you've had over the last 2 semesters. So it's a very confusing situation.
Some money on paying for classes that are not.
Be sure you get your 12 hours.
Representative Sinkfield, do you have another question?
Oh, just quickly, I like the bill. I'm just curious as to how will people who have all these years know that they can't insure their child once they're over 19? Will insurance companies write that when it's time for renewal, or let them know? How do you notify? How will people know to take advantage of it?
I am under the assumption that the insurance companies will notify as part of their policy provisions.
Representative Davis?
"25 years old,
So if they're at home, no job, no school, just living at home, we're going to cover them up to the age of 25 now. No disabilities, no nothing. Is that...
It doesn't particularly say no school. They can be part-time students and they have a part-time job. Having a part-time job doesn't take you off the dependent status of your parents or your guardian. I'd rather have them insured this way than to have them not insured. The premium is probably going to be about the same. If mom and dad's been paying it and they want to continue to pay it, it's better than us paying it as taxpayers of the state of Georgia when they have a problem and there's no coverage.
And one follow-up question. What about current families that have a 23 or 24-year-old that aren't covered? How?
This bill basically addresses those people that do have them covered currently, and there's going to be a gap there.
So is there an effective date as of everyone up to a point? I mean,
not in the bill.
Any further questions? Any further questions of members? All right, Representative Maxwell, I'll recognize you for a motion.
I would recommend that we do pass.
Thank you, Mr. Chairman.
All
Thank
those in
you, committee.
favor, please raise your right hand. Opposed, like sign. All right, we have House Bill 1484, Representative Tumlin. I almost said Representative Clemens.
Mr. Chairman, may I ask Ben Pruitt could join me and I'll introduce him. Accompanying today is Ben Pruitt, who is chairman of the Legislative Committee of the Fiduciary Section of the Georgia Bar Association. I would like just to give an overview of 1484. This is basically affects Title 33, 24-3 in our Georgia Code. And this bill is meant to clarify and have a better understanding as to who has an insurable interest in one's life. This goes to trustees, business relationships, business trusts, group insurance. This bill was motivated by a rendering this summer of a Virginia Federal District Court, which came down and narrowly construed a Maryland statute that denied somebody having an insurable interest in another's life. It was basically a trustee. And this bill, I think, not only affects lawyers, but a lot of people. We have financial advisors, CPAs, estate attorneys, insurance agents that give a lot of advice as to estate planning. You know, in relationships. In our current law, bills that were made before 1992, most of them refer to corporations, you know, talking about shareholders agreements. But, you know, since then we have more and more partnerships. We have LLCs. And what this bill is also expanding to make sure that to me, I mean, the chairman brought up a good point in subcommittee. To me, it's not just this, the unfortunate lawsuit that the law decision came down last summer, but it's that any time it could be narrowly construed, and there's our code does not address enough situations to, you know, where we could have an unfavorable ruling in a Georgia court. This was drafted by the fiduciary law section of the Georgia Bar, and I'd like to, you know, maybe before any questions, whatever y'all choose, is let Mr. Pruitt to give more detailed presentation.
I think probably you might want to just hit on the highlights, and then we'll see if we have any questions. I'd rather just go ahead and address the questions directly that they might have. But if you'll just go take us through and give us the.
Okay. The first issue has to do with specifically recognizing that a trustee of a trust can have an insurable interest if the grantor of the trust is the insured, or if the grantor of the trust has an insurable interest in the insured, or if the beneficiaries of the trust have an insurable interest in the insured, because that is not specifically dealt with in the statute. And again, our concern is that if there are interests that are not specifically set out in the statute, a narrow reading could result in saying that there was an intention to exclude those interests. And so the kinds of trustee interests that we have listed in the statute are the kind that are very run-of-the-mill in the estate planning context. Just to eliminate any doubt, much like we were discussing with the last bill that you all were discussing, that if the law is a little bit unclear, it's better to eliminate doubt and make the law more certain. The question was brought up in the subcommittee about whether this is essentially a solution in search of a problem, because one rogue court came up with an odd decision in Virginia, and do we think that that's really cause for concern here in Georgia? And the answer is that an overly strict reading of the statute can happen anywhere, and once it's happened someplace, I think that puts us on notice that a similar statute that doesn't have the degree of specificity that this court was looking for could run into the same kind of problem. The second issue, as Representative Tumlin said, has to do with recognizing that corporations are not the only business entity that people are operating in nowadays, but with more and more frequency, most small businesses and closely held businesses are operated as LLCs and partnerships, principally because the tax laws have changed over the years to make those more attractive forms of business than a corporation is. And very common business planning practice is for there to be redemption buy-sell agreements, which call for the business to buy out the stock of the owners at death, or cross-purchase buy-sell agreements that call for the owners to buy out each other on the death of an owner. And the most logical way to fund those agreements is through the use of life insurance. And where we have a statute that specifically addresses corporations and specifically addresses redemption buy-sell agreements, that could be read narrowly under the idea that, well, if the legislature specifically recognized those interests, then it meant to exclude anything else. Of course, another way to read that is to say that corporation really means business and shareholder really means owner, and they really mean any sort of legitimate buy and sell agreement. But I think that it's dangerous to try to rely on that kind of an expansive reading of fairly specific language. So those are the two major changes to the statute, and they have been designed not to make any change to what we believe the law is or to expand the law of insurable interest, but only to recognize and eliminate doubt as to the more common types of planning techniques that are being employed and that could be in danger if there was an narrow reading of the statute. Because people go to a lot of trouble to put in place carefully thought out, responsible plans to take care of their families, and we don't want to have them blow up in their face later on because of some incorrect reading of the statute.
All right, thank you. Let me just make this announcement. We have to vacate this room at noon. There's an education meeting after us, so before we start questions, I want you to be aware that we're working on about 12 minutes remaining before, in the committee hearing time. And we also have a matter that we need to address, which is that on the due pass on House Bill 1456, we should have had a due pass on subcommittee substitute to House Bill 1456. All right, any objection? Second? All those in favor? Okay, then any questions then back on House Bill 1484? House Bill 1484, Representative Sinkfield.
Thank you, Mr. Chairman. Could you just quickly summarize what happened in the case that you brought your attention to introduce the bill? I think I understand that. If you could just tell me what happened briefly.
Yeah, what happened in this particular case is that the insured, a fellow named Geisinger, he applied for a policy of life insurance where the owner and the beneficiary of life insurance was going to be the wife of his physician. I don't know what was up with that, but that was Chawla, which was the name in the title of the case, Mrs. Chawla was going to be the beneficiary of this $1 million life insurance policy. The insurance company refused to issue the policy because they said that she did not have insurable interest. He could have bought the policy on his own life because you have an unlimited insurable interest in your own life and named anyone he wanted to as beneficiary, but he set this up to name her as the initial owner and beneficiary, and that was probably tax motivated, the common thing to do. So instead, when the insurance company turned that down, he created a trust of which he and Mrs. Chawla were trustees, and of which Mrs. Chawla was a beneficiary. I think he was a beneficiary during his lifetime, and then she was beneficiary after his death. And so this trust purchased a $1 million life insurance policy, and the insurance company let that go through. Shortly after that, they increased the coverage to $2.5 million. Now, in the process, the insurance company asked very specific questions, like, in the last 5 years, have you been treated for medical conditions? Have you had any surgeries? Have you been treated for alcohol abuse? And his response was that he had had a physical, and that was it. I think there was one other urologist meeting with a biopsy that came back negative, but he said that his physical, interestingly enough, conducted by Mrs. Chawla's husband, Dr. Chawla, came back giving him a clean bill of health. After he died, about a year or so after the policy was issued, it came to the insurance company's attention that, in fact, during the last 5 years, he had had brain surgery in Austria to remove a tumor. He had had numerous spinal taps. He had had numerous neurological disorders, many of which were related to chronic alcoholism, which had been diagnosed on several occasions, and he had been hospitalized for it on several occasions. So in this case, there was very clear fraud in buying the policy, and so it was really unnecessary for the court to even get to the issue of insurable interest. And as far as I can tell from reading just the case, it doesn't look like the insurance company brought up that issue in order to deny coverage. But the court, after holding that there was clearly, misleading information provided to the insurance company, then went on to say, and besides, there's no insurable interest because the Maryland statute doesn't specifically say that trustees of trusts have this interest. So it was, an unnecessary decision, and it seemed kind of odd, but it has caused concern throughout the country, because if they're making the general rule that there is no insurable interest if the statute doesn't specifically say it, that implicates a lot of places like Georgia. And as a result, we've got this bill. Maryland is updating their law. I think I saw that South Dakota and a couple of other states likewise are updating their laws, much the same way that legislatures everywhere are looking into their eminent domain laws. So that's the history of the case. Yeah, there's the fiduciary law section of the State Bar of Georgia, which I must confess is, it's primarily, I'm the one who saw the problem and recommended that it be fixed, and as the chairman of the committee, I had the privilege of doing all the work on it too. So anything in here that, is purely my doing, and I take responsibility for it.
Lieutenant Murphy.
Yes, sir. I'd like for you to just clarify a portion of the language in this bill for me. A corporation or individual that is deemed to have an insurable interest in an insured, will they be allowed to purchase coverage on that insured without that insured's authorization? Is any language in this bill dealing with that?
I don't think there's anything dealing with that specifically. My understanding has been that you can't buy, that nobody can buy a life insurance policy on somebody else's life without their consent. If I'm incorrect about that, I would have no objection to that being added, but I think that that's the law now.
Right, but that, basically what I'm asking, you're not proposing in any portion of this language to change that?
Oh, no.
Okay.
Absolutely not. And as I had pointed out yesterday, and I won't belabor the point, but I recognize there is another bill, this House Bill 443, that was, by people in the life settlements industry that has been proposed to expand insurable interest to anybody that wants to buy a policy if they have the insured's consent. And that's not our bill, and that's not what we're proposing, and we have nothing to do with that.
All right. Any further questions? If there are no further questions, then I'll accept the motion.
Do pass HB 1484
All those in favor, raise your right hand. All those opposed, like sign. Appears to be a do pass.
Thank you, Glenn.
Thank you.
I'll accept the motion to adjourn. Thank you, members, for attending this morning.